Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukkar. In this video, I am going to touch upon a Supreme Court judgment regarding Parents and Senior Citizens Maintenance Act 2007. The crucial point is the tribunal chaired by the RDO for this particular act, enforcement of the act, they can, please remember, they can award the so-called cancellation of the gift deed. They can award the transfer of property back to the senior citizen. Tribunal, yes, is empowered to do like that, basing on section 22 and 23 of the same act. This is Parents, Maintenance of Parents and Senior Citizens Welfare Act. Right. Supreme Court said the Maintenance Tribunal has got power to evict and transfer the possession in favor of the applicant, senior citizen also. Justice C.T. Ravikumar and P.B. Varale. 1 minute. Justice C.T. Ravikumar and Sanjay Karol. In the case of Urmila Dixit versus Sunil, Shran, Dixit and others. This is Civil Appeal number 10927 by 2024. Decided yesterday. That is on 2/1/2025. So, first case decided in the New Year by the Honorable Supreme Court of India. Of course, in our videos, it is the first case. Court clearly held that, yes, the tribunal has got powers to evict the fellow if he has unlawfully occupied the house, to transfer the property even though the gift deed is returned. ఈ కేస్ ఫ్యాక్ట్స్ తెలిస్తే మీకు ఈజీగా అర్థమవుతుంది. రైట్. సో ఉమా దీక్షిత్ and husband, they have become senior citizens, old people. Okay. Then she has given a gift deed of certain property to her son. Actually, she purchased the property on 23/1/1968. Now, having become old, she got the hope of the children will look after her కొడుకు సునీల్ శరణ్ చూస్తాను ఉద్దేశంతో వాడికి 7/9/2019, about 4 years back, she has gifted the property, కానీ దాంట్లో on the condition that he has to maintain her and he has to make provisions for he has to maintain the parents and he has to make provisions for them. Okay, gift deed was done, but eventually what happened is, after taking the property, or simply saying after grabbing the property, the Sunil Sharan is not looking after her and her husband properly. Right? So, therefore, in the next year, that is on 24/12/2020, woman, that is Urmila Dixit, she filed an application under section 22 and 23 of the Welfare, Maintenance and Welfare of the Parents and Senior Citizens Act 2007 before the concerned RDO, that is Subdivisional Magistrate Chhatarpur. Why? She alleges that the child or their son, Mr. Sunil Sharan, is not looking after them, and that means Urmila Dixit and her husband attacked them and also abused them in the unparliamentary language, due to which the so-called love and affection were gone. Therefore, she wants the gift deed to become null and void and transfer the property, or she wanted to revoke the deed, revocation of the deed and get back the property. This is the thing. But please remember, according to the Transfer of Property Act, if you once transfer the property to the other person by way of gift, by way of settlement, whatever it is his property. Then, if you want to get back the property, of course, it is a conditional transfer, She has put a condition that if he looks after them properly, okay. If that does not, it will revoke. So, if such is the scenario, even though the condition is not there, if the said Urmila Dixit is able to prove that her son has ill-treated her, then according to this act, here she can get back the property even in spite of the provisions of the Transfer of Property Act. Please remember, as per the provisions of the Transfer of Property Act, if you wanted to revoke the deed, you have to give a notice to the party. That means here she has gifted the property to her son Sunil Shran. So she has to give a notice to him and he has to raise the objection and then you can get it revoked through the sub-registrar office. That's the procedure there. But as far as maintenance, now the problem is like this. Since it is concerned, Maintenance Act is concerned, yes, the tribunal has got orders to evict them from that place because having taken the property as gifted, he has occupied the same. But now the tribunal asked him, vacate the premises within so and so date, and the property was once again transferred back or the deed is revoked. Will the son keep quiet? No, he has approached the High Court. Please remember, when the tribunal declared the deed as null and void, then he filed an appeal before the High Court. Single judge said no. Tribunal is correct because we have not looked after them properly. He is 100% correct in getting back the so-called property. Dismissed. High Court also did not agree, but they have placed the matter before the division bench. Please remember, here the division bench set aside the order of the single judge, holding that the tribunal has got no power to revoke the deed. Tribunal has no power to get the property back. Tribunal has no power to hand over the property to them. But here the important point is, no doubt tribunal is there. According to the opinion of the division bench, tribunal is there to decide whether the gift deed is properly acted upon or not. That's all. But regarding the orders, transfer of property, revocation of the deed, only High Court or concerned court has to do, not the tribunal. This is the opinion of the so-called division bench. So, agreed by this Urmila Dutt once again came to Honorable Supreme Court of India. Now they have given clarity. This is the beauty of the interpretation. Supreme Court and High Court are there to interpret the statutes. Right. Please remember the Welfare Act, that is Parents and Senior Citizens Maintenance Act, is a beneficial piece of legislation. Beneficial piece of legislation. At the fag end of their career, the parents, they expect their children to look after them properly. If they don't look after them, then the tribunal is there to solve their issues because it is a remedy, speedy remedy. Instead of going to the court, they can approach the tribunal, that too by an executive officer like the RDO. Yes, tribunal has got all powers to act like a court. This is the verdict of the Supreme Court. So case law, beautiful case law they have touched. That is S. Vanitha versus Deputy Commissioner, Bengaluru Urban District and others. 2021 case. Then, as usual, they touched Rajneesh versus Neha, 20,000 rupees, and ultimately held that yes, the tribunal is competent to revoke the deed. Now the air is clear, the interpretation is clear. So you can take advantage of this case whenever you argue on behalf of old people like us. Okay, with this I am concluding. Thank you very much.